Read that sentence again.
Read your last sentence.
Read the last sentence you were just reading.
Between Mitchell inviting Detective Sachs into my client's room and Mitchell stopping halfway through typing the password, the situation remained unambiguous.
What does unambiguous mean to you?
Unambiguous means that there was nothing that there were no facts that indicated that something was amiss or wrong.
Okay, so let's go from there, but I wouldn't even want to say that, okay? Because your whole thing is that, you know, there's this ambiguity, so you want to avoid maybe that word, and I thought maybe you're just misusing it by saying. So up until a point, it was okay for the detective to keep doing what he's doing? Is that what you're trying to say?
Yes.
Okay.
But the cases allude and specifically say ambiguity or non-ambiguity. He has to clear up an ambiguity. So he's got to include that word.
Okay.
Basically what I'm trying to say is like there was nothing between him entering the room, entering the room and before Mitchell did the sign that would have alluded to there being something wrong.
Maybe to say up until this point, the situation was not ambiguous. Okay. I would. Unambiguous means like, oh yeah, go for it. You know, anyway, but you know what you're doing. I don't. Okay, so when you're ready, start the sentence again, and when you get to the point where I interrupt you, I'll start time again.
Between Mitchell inviting Detective Sachs into my client's room and Mitchell stopping halfway through typing the password, the situation remained unambiguous. However, when Mitchell stopped typing the password halfway and gave the detective the shh sign, ambiguity was quickly created as this sign is usually used by someone to admit conscious wrongdoing.
Counselor, I see where you're going with this, but how does United States versus Aaron relate to your case?
Well, Your Honor, in United States v. Aaron, the third party in this case is Mays, the defendant's girlfriend. And, sorry, Your Honor.
You can distinguish it.
Okay,
In
so
this
when the judge says, can you distinguish counsel, what they're asking is, what's the difference between this guy, he was assigned to his roommate, and the man's girlfriend who lived in his house? So, can you easily, what's the difference?
In United States v. Aaron, the defendant's computer was not password protected. However, in our case, my client's personal laptop was protected by a password that, to his knowledge, only he knew.
I see. Continue, counsel.
This interpretation of the sign can be supported by Mitchell on page 45's lines 24 to 26 with, that's why I need the shh sign, because I don't think Haley knew that I knew the password. Mitchell's statement also reveals how Mitchell dubiously found out the new password. After my client changed passwords, Mitchell wasn't told the new password, but Mitchell was able to find it. By looking over my client's shoulder purposefully when hanging out with my client, Mitchell consciously memorized the new password when my client was typing it. Going back to the sign, an ambiguous discovery like this is relevant, as in United States v. Purcell, 526 F. 3rd at 953, establishes when a situation starts as unambiguous but subsequent discoveries create ambiguity, any apparent authority evaporates. In order to reestablish apparent authority, it was necessary for Detective Sachs to resolve the ambiguity before relying on said authority to continue searching, as established in the United States v. Griswold, number 9 CR 6174, where an officer is presented with ambiguous facts related to authority, he or she has a duty to investigate further before relying on the consent. Yet, despite Detective Sachs admitting in Detective Sachs' witness statement on page 38, lines 20 to 21, with Mitchell halfway through entering the password, did pause to hold his index finger to their mouth, which I took to indicate shh. Detective Sachs recklessly continued the search of my client's laptop without any valid third-party consent, as United States v. Purcell also held apparent authority cannot exist if there is ambiguity as to the asserted authority and the searching officers do not take steps to resolve the ambiguity. I've already mentioned how Mitchell dubiously obtained my client's new password. And since my client didn't know about this, my client would have had a clear expectation of privacy for its contents. On top of this, my client...
Counsel, but how can we charge Detective Sachs with knowledge of the roommate getting this password illicitly?
Well, Your Honor, the reason why my, sorry.
Let's wait for the announcement. Well, and you can think.
National City Engine 34, Medical, 6 Charlie, 6 Delta, 220 East 24th Street, Windsor Gardens of SD&NC, SRF, Unit 30 BEDV, Cross Streets, B Avenue, and D Avenue, National City Engine 34, 6 Charlie, 6 Delta.
Your Honor, would you repeat your question?
Sure, so my concern is this, if our determination as to apparent authority to consent to a search is based on what is apparent to the detective at the time of the search, why should we be concerned about how the roommate got the password in this case? Sure, why, if the concern is the apparent authority as it appeared to the detective at the time, why is the way that this roommate got the password, why is that relevant at all?
Well, Your Honor, this relates back to the sign that I keep mentioning to the court. The reason why Mitchell had done the sign is that because he consciously knew that my client didn't know that Mitchell knew the password. By doing that to the detective, he was consciously admitting to it. Yet, though he didn't tell the detective yet why he did it, doing the sign was a prelude to what the detective could have found if he had sufficiently investigated the sign.
Okay, so how does the free case help you then? Trulock be free.
Well, Your Honor, in Trulock v. Free,
Okay, and if this happens during the competition, the judge will
Yeah.
feel your pain and he'll say, continue, counsel.
That's okay, so
So what are you trying to
Trulock, we had, both of those individuals had access to the computer. What was different about Trulock that made us both decide that there was no apparent authority to consent for the search there?
The officers were told that both the third party and the defendant maintained separate password protected files on the computer's hard drive.
And how is that like what we have here?
In our case, my client had changed the password without telling Mitchell the new one. So, which means that he was trying to lock Mitchell out of accessing his computer, the computer again.
Okay, continue.
Okay, and before we continue, okay, what might this mean? Okay, so your mom told you, okay, those cookies are for the party tomorrow, don't you boys eat them tonight, okay? And you go down to the kitchen during the night to get a glass of water and you see your little brother taking a cookie and he does this, meaning it's our little secrets, our little secret, don't tell anybody. We're not supposed to be doing this. Okay, so you might want to kind of try to work that into. Okay, so when you're ready, counsel.
On top of this, my client clearly had left the door to their room closed. As established in United States v. Caro, 468 U.S. 705, 725-26, courts are reluctant to approve third-party consent searches of an enclosed space in which the individual targeted has clearly manifested an expectation of exclusivity. By leaving the door closed whilst away and leaving the laptop in the room, my client clearly wished to keep the contents of the laptop private. It is also to note that Mitchell discloses on page 45, line 7 to 8, that Haley never said
30
specifically
seconds.
that I could use the laptop anytime. Finally, I would like to reiterate to the court that Detective Sachs unlawfully continued searching my client's laptop despite not clearing up any ambiguity with Mitchell's asserted authority over the laptop. This is why, Your Honor, that our motion to exclude Exhibit A should be accepted. Thank you, Your Honor, that'll be all.
Perfect. 354.